3 people haven't. Okay. Okay, don't let the people in. I can see.
Okay, so good morning, everyone. I hope you can hear me. Can you hear me?
Yes,
okay.
you can.
Okay, so thank you. So welcome to today's session. My name is Amanda Maseno. I'm a young mediator. I also liaise with Wasilianahub, and I'm happy to invite you to this session today. So first and foremost, I think I'll begin by welcoming you all to the session. Thank you for joining in. Thank you to those who could make time today to be able to join in to this session. So we will begin with the national anthem, the Kenya national anthem, and I'll just recite the words in Kiswahili. So I will begin. Wimbo wa Taifa. E Mungu nguvu yetu, ilete baraka kwetu, haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi. Okay, thank you. So welcome once again to the African International Mediation Week. Today is the 1st of December 2020, and it's a new month. So welcome to the new month as well. I'm excited as a young mediator to begin this session and to really engage with people from different parts of the world, different walks of life. I'm very excited and enthusiastic about this session. I'm eager to learn quite a bit from the panelists, from the speakers today. And I hope we can have an engaging session and we can be able to answer questions and discuss the way forward in terms of mediation and how we can be able to grow together as one global entity. So I think I'll just go straight into our topic for today, which is the Africa and the Singapore Convention on Mediation, a new era for international commercial dispute resolution. Our facilitator for the day will be Wangari Kabiru, who is a chartered mediator and convener of Wasilianahub. And our international speaker will be Ted John Lin. I hope I got that correct. Deputy CEO, the Singapore International Mediation Center, SIMC. Our second international speaker will be Lee Zumin, Center Manager, SIMC. And on the panel, we will have, we will be discussing implications to the national and regional trade policy frameworks. And our first panelist will be Juwon Adenuga. I hope I also have that correctly. Who's the chairman advisory board, ODR African Network, Nigeria. BSc Estate Management, established Adenuga and Company, a firm of estate surveyors and valuers, fellow of the Chartered Institute of Arbitration in the UK, CIARB, and a certified mediator as well. Our second panelist will be Jacqueline Oyugo Githinji, who's the non-executive director, NAIROBI Center. Sorry, Oyuyo Githinji. Sorry for that. Non-executive director, Nairobi Center for International Arbitration and CIA, Kenya. Managing partner, Umsizi LLP. Fellow for the Chartered Institute of Arbitrators and a certified and court accredited mediator. She also has an MBA in Global Technology Management. Our next panelist will be William Agan, Catholic University of Eastern Africa, KWER, Faculty of Law, a certified mediator and advocate of Agan and Associates. So I would like to welcome you all to this session, and I hope to have a very engaging session with you all. I would like to now bring in our facilitator for the day, who is Wangari Kabiru. Thank you.
A warm welcome from myself and also from the entire team at Wasilianahub. And we are extremely delighted that we can be able to share this time with you. You are part of a vision that has been on for just about 3 years, and we are greatly delighted that you honored us by accepting our invitation to be a delegate, to be a speaker, to be a participant at this particular forum that we have today. So as our host for the session today, young mediator Amanda Maseno has indicated, our session today is on the International Commercial Mediation, and it is part of the African International Mediation Week 2020 and Strategy 20 Conference, which is running from December 1st to the 4th of December. It is a virtual forum. And today, our session on Tuesday, 1st December at 9 a.m. East Africa time, our topic for today is on Africa and the Singapore Convention on Mediation. And aptly put, a new era for international commercial dispute resolution. So I'm a facilitator, Wangari Kabiru, a chartered mediator and convener of Wasilianahub. At this juncture, I wish to invite our colleagues from the Singapore International Mediation Center, who will make a speaker's presentation to support us to understand the Singapore Convention on Mediation. And at the same time, they will also help us to understand a bit more about the Singapore International Mediation Center. So kindly, I welcome Jolene and Madame Lee. Welcome. Thank you.
Thank you, Wangari, and thanks everybody. I think while Jomin loads the slides, maybe I'll say a few words. First, thank you very much from Singapore, from the Singapore International Mediation Center, to all of you who I'm seeing now. Actually, I'm a little bit humbled now to be here, and I wonder what I can share that you don't know already. But I'm quite happy to be here to just share what we know, what we see about mediation, about the convention. And to the extent possible, I would like this to be a session where we can just have a free-flowing discussion later on during the panel as well. So we can all just learn from each other. And I think in a different time, we'll be flying to where you are to just speak to you. But actually, Zoom is also good enough, and I can feel your warmth over Zoom. So I think without further ado, what we'll do is that we'll go through some slides that we have, and if there are any questions, just feel free to stop me and stop Jomin.
Hi, I would need the access to share screen, please.
Okay. Yes, Amanda, kindly, yes, could you kindly co-host? Thank you.
Thank you, Amanda.
Oh, yeah. Sorry, give me a moment.
Okay, thanks very much, Jomin. So before I start, as I said earlier, I'm Julin, Deputy CEO at SIMC. So my journey in mediation has not been that long, but in the past few years, I've seen enough to see the traction growing in the area of international commercial mediation. So I'm a lawyer by training, and after that, I was in the courts for a while, and I went on to the Singapore Ministry of Law, where I was involved in the Singapore's policy positions for Working Group 2. That is the working group that discussed the text of the convention, and that's led to the convention that we know today. And more recently, last year, I was also involved as part of the team that was trying to implement the obligations of the convention into domestic law in Singapore. And earlier this year, I then joined SIMC. So here I am now, and my colleague now is Jomin, who has been at the center for longer than I have. So later on, she'll have a lot to share too, from her perspective on mediation and how people around the world are responding to mediation. And we'll base this based on our experiences, speaking, meeting before COVID, flying to various places to meet with people, business leaders, lawyers, government officials from places like China, Japan, Korea, India, and even beyond. All right, next slide, please. So maybe what I'll start with is just a photo of how mediation looks like. So the caveat here is that mediation is confidential. So this picture was taken from a real mediation, or we got the permission of the lawyers who are in the room and the mediators to take this picture. And I thought it's important to start the presentation by just showing us a picture of mediation today, which could be quite different from how you experience it. So in this picture, maybe I'll just orientate you a little bit. On the left, we have two mediators for this case. They're on the left side of the table. And for SIMC, at least for our mediation, we try to arrange the tables in a circle so people can all just speak to each other. And I think it could be the same in your country as well, because it's not meant to be adversarial. It's not meant to be like court proceedings where lawyers are sitting aside from each other. Rather, you can see each other, you can speak to each other freely, and the entire setup is meant to promote discussion, so people can talk it out and not fight it out. And it's COVID-19 this year, so in a different place, people will be flying here and flying there for mediation. So this case actually involves parties who are in Singapore, in Hong Kong, and also in Europe. So what we have found that this year, due to COVID-19, people can actually mediate via Zoom. So this is what we call a hybrid mediation. So we had three parties all gathered in the same room, speaking with the mediators behind closed doors. So it's private, of course. But we also have people who are logging remotely via the internet, as you can see from the screen on the far side. So this is a picture that I thought I would start with on international commercial mediation in this time and in this age. Next slide, please. So people are asking now, why mediation? And before we go into the impact of the Convention on Mediation, maybe I can go a little bit into the benefits that are inherent to mediation. So I think that the key thing about mediation is that it's often compared with the other forms of dispute resolution, like arbitration and litigation. And to me, the first bullet point is swift. So in our experience at SIMC, mediation can take as short as 1 month to be organized and concluded. If need be, we can do it faster. It's inexpensive. So people often ask us how much it is to do a mediation for a complex commercial case that may amount to US millions of dollars. And we tell them that it's only a very small fraction of what it will cost you to proceed to court and engage in trial proceedings and enforcement proceedings. And it's also compares very well to arbitration, for example, as a way to resolve disputes. And effectiveness, what I can say here is that people often wonder about whether it's very effective. And I can tell you that at SIMC, for example, 7 to 8 in 10 of our cases result in a settlement. And even for the 2 or 3 in 10 for which there's no settlement, parties are often clearer about where they are, where their positions are, and that helps them as they proceed to the next stage, which could be preparing for arbitration or litigation. So quick, cheap, and also effective. This to me is a very key point about mediation that we're happy to explain more later. And of course, as you can see from the picture earlier, whatever happened behind closed doors stays behind closed doors. So mediation is confidential, and that's a very important property of mediation. And without prejudice, in the sense that we all know that that means that whatever you use or say in mediation cannot be admitted as evidence in further proceedings in the court, for example. High settlement, I've gone into that. More than a win-lose, 50% chance you win, 50 you lose. We talk about win-win approach. And I think that Africa has a long tradition of like mediation, negotiation as a way to resolve disputes. And it's the same in Asia. It's the same in Singapore as well. So when a win-win, you talk it out, you don't fight it out. It's not a win-lose paradigm. It's a win-win paradigm. And later on, I'll explain the case study just to drive this point home. And it's especially important in our view for long-term commercial contracts. For example, maybe a gas contract 14 years, 21 years, where it's very important for parties to stay together even after a dispute has happened. Creative solutions, I'll explain that through a case study later, and flexible. So people often think that if I use mediation, I can't do anything else. That's not true. Mediation is good enough to use on its own, but it's also very good to be used together with arbitration or litigation. So in some countries, for example, I think Italy, for example, you're supposed to have mediated first before you go for litigation. And that means that a good number of disputes that can be settled are settled early. And even if you proceed straight to litigation, arbitration, you can always, at some point in time, decide to go for mediation. So it's flexible, it's plug and play at any stage. And for a case study, maybe what I can share is a case that happened at SIMC earlier this year. So this case is an international case. This case involves the an international lifestyle technology company. So it's a tech company, and it produced some products, lifestyle wear products. And what happened was that this company discovered that somebody was selling those products without permission and infringing its trademarks on online platforms, websites. So the company went after this person and wanted to sue this person for millions of dollars. But the problem is this person is not a big time player. He's not able to pay the trademark infringement damages. He's not able to make restitution of the sums that he profited from as a result from the illegal sales. So they came for mediation, and over 1 day of mediation, they could not resolve the dispute. But towards the end of the day, they had a breakthrough. And the breakthrough came when they discussed and they realized that each party could give the other party what the other party wanted. And what was that? So it turns out that this company had some problems trying to track everybody else in the supply chain. So the company wanted to investigate just how those goods left its factory and came to be sold on the platform. And this seller was able to provide information on that. So in the end, the company and the person, they agreed to collaborate so that the company can try and track down the bigger fish in the syndicate, in the chain. And the company also allowed this unauthorized seller to pay a smaller sum, I think, by installments. So let's take a step back and think about this, right? So they settled and both sides got what they wanted. The company managed to get more information that it was after to stop such things from happening ever again. And on the side of the seller, he got what he wanted because he doesn't want to be faced with millions in debt from a lawsuit. But instead, he can share what he knows, he's off the hook, and he can pay a slightly smaller sum and installments. So this solution is something, for example, that we say that it's quite difficult to get in court because we all know that when you go to court, it's a win-lose. Quite often, the court will only order damages, a monetary payment, and you don't even know whether the other person is able to pay on the judgment debt. And that's important. Why? Especially in a period like now, COVID-19, as what me and Juan were talking about just now. You don't even know, people are hurting from COVID-19. You don't even know if they're able to pay on their debts, for example. So in this scenario, we think that benefits of mediation are greater than ever. So I'm happy to go into that later and talk more, but for now, I'll go on to the next slide. Thank you. So I spent a little bit of time talking about the time and the cost savings. And in the EU, they've done some research on the cases that have gone for mediation. And what they have found is, maybe I'll show you the left chart first on the left. You will find that at 19.5%, 19%, even if you have a 19% chance of succeeding in the mediation, you will be saving time. So a 1 in 5 chance of success allows you to start saving time as opposed to going through the actual court process. And it's similar when you look at the chart on the right on the cost savings. At 24% and above, success rate, you start seeing cost savings. And these savings are not small, yeah? If you look at, say, 75%, for example, you'll see almost 6,000 euros in cost savings. And 75% is about the settlement rate that people actually settle at. Like about 10 out of 10 cases, 7 to 8 actually result in a resolution. I mean, at least from our experience. So you can see just how time and cost saving mediation can be as a way to resolve disputes. Next slide, please. Yeah, next slide. So why mediation now? Before I go into the convention, I think I've basically gone through what are the inherent benefits of mediation. And this is the Singapore International Dispute Resolution Academy survey. It's a body in Singapore that studies and researches a lot on dispute resolution around the world. And what they did recently is that they published this survey after surveying more than 300 users around the world. And maybe I'll just orientate you to the charts, to the columns on the right side. You see speed and cost. And you will find that for mediation, it's 85% for speed. And for cost, it's 81%. What does that mean? That means that people who use mediation, they value mediation for its speed and cost. Yeah. And but maybe, yeah, and I'll go to the next slide. So they asked another question about how satisfied you are from using your choice of dispute resolution. So I'll go back to speed and cost again, and you look at mediation. People who use mediation, they are far more happy with the speed and cost of mediation than people who use arbitration and litigation, for example. And of course, I'm not saying that there's no role for other forms, but recall what I say about how you can match mediation in arbitration, you can match mediation in litigation, you can do it alone. And before I move on to the next slide, I will show you something that was very interesting, which is enforceability. So if you look at the leftmost part of the chart on enforceability, maybe I'll go back to the next, go back one chart, Jomin. Okay, so this is the importance that people attribute to a particular way of resolving disputes. If you go to the first column, enforceability, you will find that people value arbitration and litigation because of enforceability. For arbitration, it's 87%, and for mediation, 67%. So what this means is that people who value mediation, they don't value it because it's enforceable, but people who want enforceability, they will gravitate towards arbitration. And that takes me to the main part of this presentation, because this survey took place before the convention. With the convention, the outcomes are now enforceable. So it stands to reason that more people who value enforceability will now consider mediation as a way to resolve disputes, which means that they get the best of both worlds. They'll get the speed and cost that I spoke about, and they will also get the ability to make the outcomes enforceable. Yeah, so I'll go on to the next slide and the next slide. And maybe at this point, I'll just pass the microphone to Jomin, who will take over and share a little bit more on the convention. Thank you.
Yeah, thanks. Thank you, Julian, for the introductions. And of course, definitely thank you, Amanda and Wangri, for the kind introductions earlier. So we now launch into the part about the Singapore Convention, and this is really, really right at the beginning. And we would like to start off this part of the session with the question: really, if you were a party to a contract, would you not want it to be enforceable? With arbitral awards, international arbitral awards, to be specific, there is the New York Convention of 1958, and in the last 62 years, thanks to this New York Convention, international arbitral awards have been able to be enforced across borders, and this really gives teeth to arbitral awards, and we can almost draw a relationship between the popularity of arbitration to the New York Convention. But during this time, there just wasn't a similar mechanism for mediated settlement agreements that have been settled via mediation. And this is particularly the missing piece in the dispute resolution puzzle, which is what the convention aims to address. So we move on to a little bit about the background and the history lesson of the convention. And really at this point, I'll just be highlighting some of the main things that have happened in the last few years. So we like to call it, the convention really is, something is an idea whose time has come. And in 2014, the United States actually mooted the idea for an international convention on the enforceability for the enforcement of international settlement agreements resulting from mediation. And thereafter, in the next few years, discussions occurred. Over the next few years at UNCITRAL Working Group 2, it was 1 year in New York and then another year in Vienna, and it was participated by 120 member states and NGOs. But the fact of the matter is that for this convention, the idea was actually sown as far back as 20 years ago. It's just that at that point in time, there was no appetite for a uniform approach. And that time, 20 years ago, being during the 2002 Model Law on International Commercial Conciliation. So in the last 25 years, we have really, I guess, come a long way. This picture is really the momentous day whereby the language of the convention was finally agreed, finally hammered out, and finally, all countries said, yes, let's just do it. And this would be the final one. And in 2018, on the 20th of December, it was adopted by the UN General Assembly. So the primary aims of the convention, and this is really the preamble of the convention, which is also stated inside the convention text. And firstly, it recognizes the benefits of mediation, which is largely what Julian had mentioned in the beginning, the time and the cost savings, as well as the idea that relationships, commercial relationships, can be preserved because of mediation. And with the enforceability question being plugged by the Singapore Convention, it is expected that mediation will be on the rise. And from SIMC's perspective, we do indeed see that mediation has been growing in popularity as a form of dispute resolution over here in Singapore and in Asia. And by extension, with the growth of mediation, with its popularity, it is expected to facilitate international trade and contribute to harmonious relations. So at this point, I suppose it is timely to actually give an analogy of why this is actually significant. Because if you think about most commercial contracts, especially in energy, in construction, these contracts are usually signed for the next 20-25 years, and parties are bound by their contractual obligations to work together for the next 20-25 years. Now, if you are in a marriage for 20 years, you definitely have conflict, you will definitely have a dispute. And how are you going to manage that dispute or reduce the risk of the dispute happening again? So most times parties would just go for arbitration or litigation, which is long drawn, it's exhausting, it's it is a waste, I would say, of resources. Whereas in mediation, we see that it's almost a perfect resolution, a perfect solution for disputes or disagreements during the course of such long-term projects, long-term contracts. And when you manage it through mediation, you resolve it through mediation quickly, effectively, and timely, your people, your project can move on, and parties can continue to work with one another, without mistrust, without acrimony for the next 10 years or so. The benefits of the convention, really, it's quite straightforward. We would say it's simple to use convention with only 16 articles. It's easy to read, it's easy to apply, and it allows businesses to really maximize the benefits of mediation. It promotes investor and business confidence in a way that we would say if jurisdictions or countries sign on to the convention, it is likely to, boost investor and business confidence for that country. And this fact is actually being backed up by a survey that was done by the International Mediation Institute in 2014, whereby a majority of the participants indicated that they would be more willing to mediate a dispute with a party from a country that had ratified an international convention which allows for the cross-border enforcement of mediated settlement agreements. And by extension, of course, you promote investor confidence, you also promote thought leadership in international dispute resolution. And more importantly, we see the convention as having a positive impact on a justice system, because through mediation, you can actually divert disputes to ad hoc or institutional mediation. And this really frees up the backlog of cases that the courts have to hear. Again, this is another one of my favorite photos, and it's the Singapore Convention signing ceremony that took place last year on the 7th of August. Singapore hosted the signing ceremony. And one of the reasons why the convention is called the Singapore Convention on Mediation is because Singapore put in a bid to host the convention, and thereafter, by consensus, the UNCITRAL or at the UN level, they agreed for the convention to be called Singapore. And also, it's also I guess coincidental to say, not coincidental to say that the Working Group 2 was being chaired by a Singaporean lady, Ms. Natalie Morris Sharma. So on opening day, 46 countries signed, and each one of these foreign dignitaries represent their respective countries who have flown all the way to Singapore to witness the signing, to sign the convention, and to take part in the week's diplomatic meetings, seminars, as well as the celebrations. And this really is one of the highest show of support that we know for a UN treaty. Thereafter, the Singapore Convention is open for signature at the UN headquarters in New York. The convention came into force on the 12th of September this year. And since 7th of August 2019 up to today, 53 countries have signed, 6 have approved or ratified the convention. And of the 53 countries that have signed, you have really big economic powers such as the US, China, and India. In Africa, several countries have signed as well, and we certainly also encourage Kenya and others to come on board together on this convention with us. In numbers, really just to give an idea of how significant the major economic powers are, that is the US, China, and India. Together, they make up almost half of the world's global GDP. Asia's signatories, and this is actually very relevant for us here in Singapore because a lot of our trade happens with our regional partners in Asia. India, China, South Korea are among the top Asian economies, followed by ASEAN. So about 5 ASEAN countries have signed the convention, and together, this whole graph that you see on the right-hand side, they make up about 71% of global growth. And these are figures that were culled from the International Monetary Fund and research from elsewhere as well. This is roughly the background and the genesis of the convention. I think it would be timely to pass the ball back to Julin to really talk about the growing demand and the trends, as well as the key provisions of the convention. Hi, Julin.
Thanks, Romain. Thanks for passing me the ball. I think before I go into the provisions of the convention, and it's very short, I assure you, I want to take a look at the impact that the convention has had on international mediation. And I don't know about a causal link, but from our perspective at SIMC, we've been seeing a growing caseload year on year, generally for the past 5-6 years. And this year was a little bit of a unique year because so far this year, the number of cases has more than doubled from last year. Sorry, not more than doubled, but actually almost doubled from last year. And on the ground, one reaction we get is that parties have more confidence in mediation now because more and more of them understand that there's a convention. Due to the convention, they have a lot more confidence in using international mediation as a way to resolve disputes. And it's also been great in raising awareness of dispute resolution generally, and specifically mediation. And of course, the other engine that I think has potentially resulted in more people looking at mediation as a way to solve their problems in business is COVID-19 pandemic that has gone around the globe, and it has made a lot of businesses go through disruptions in their contracts, in their arrangements. And people are realizing that I can't be going to the court to solve every problem during this period because I have no time. I'll be out of pocket. And what I really want is an outcome that will allow me to readjust my business and trim my sales so I can proceed and try and stay afloat during this very uncertain business climate. So convention and COVID-19, the two C's are two factors why we think that there's been a growth in interest, if not in the actual cases, for international mediation. So on this note, I'll next go into a further segment of this presentation, and that will be just a very quick glance of the key provisions of the convention. Next slide, please. So this Jomi went through earlier. This is a preamble, and my own preamble is that the convention actually is a very short treaty by treaty standards. So if you take a look, it's no more than a few pages, 16 short and sweet articles. And I think that really speaks to just how simple to use mediation is and should be. Next slide, please. I think one important point that is important to set here is to note that the convention applies to an agreement that must result from mediation. And mediation actually is construed very widely. You need a third party neutral to be a facilitator to assist parties to resolve their dispute. So that means that pure negotiations where it's one party on one side and one on the other side talking through their own problems does not count as mediation. But apart from that, what is mediation is very broad. An agreement that results from mediation is caught by the convention. However, the scope must be a commercial dispute. But again, I will explain that what is commercial is also very, very broad, right? It can be almost anything to do with business, investor state, oil and gas, exchange of money and all that. And international, also very broad again, in the sense that, for example, one party here, one party in a separate country, or maybe a large part of the performance of the agreement is done overseas. Yeah. So the key points here, commercial and international, and for mediation. Okay, and at the same time, even though I said it was broad, it doesn't apply to everything. So the convention is quite clear that it does not apply to consumer disputes. So for example, a personal, family, household, employment law dispute, it does not apply. So purely commercial, mainly business disputes. And the second point is that if your agreement is potentially enforceable in the court as a judgment. So for example, you went for mediation, you got an agreement, and you are able to bring it to the court and have it recorded as a court order. Or you can bring it to the tribunal and have it recorded as an award. Then you cannot then use the same agreement to go under the Singapore Convention. And that's to prevent overlap between different regimes, because as you know, For judgments, you have, for example, the Hague Choice of Courts Convention. And for arbitration, you can enforce your award under the New York Convention, which can be enforced in, I think, at last count, 164 countries, I think. So there's meant to be no overlap. But what it also means is that the convention plugs the gap. Okay, so definitions, very straightforward. International, as I said, is inviting and recorded in any form and must result from mediation. And I mentioned earlier about what mediation is, right? So I compared it to negotiation. So Article 2.3, I can read it out for you, is a process irrespective of the expression used. And that's important because in some countries, they call it conciliation, but it's the same thing. And parties must just simply attempt to reach an amicable settlement of the dispute with the assistance of a third person, the mediator, who lacks the authority to impose a solution upon the parties to the dispute. So that's the definition of mediation. And that's also what we practice day in, day out at SIMC. Next slide, please. Okay, so this is the bone and marrow of the convention, because it tells you exactly what it's meant to do. The two key prongs of the convention. So the first prong is Article 3.1. Each party to the convention, and party here refers to a state that signed the convention, okay, shall enforce an agreement in accordance with its rules of procedure. So it can be rules of court, its own internal rules, and under the conditions laid out in the convention. And 3.2 talks about using an agreement as a shield. So for example, if a company is being sued by another company, but they had already resolved their agreement previously, the country that signed the convention must allow the party to invoke that agreement to prove that the dispute had already been resolved pursuant to mediation. So these two things are the bone and marrow of the convention. One, you allow a party to enforce its agreement in a jurisdiction that signed the convention. And two, you allow that party to raise the agreement as a shield in case it's being sued all over again in the jurisdiction, even though the parties had already settled the dispute. So very simple, and these are the key principles. Article 4 then tells you what you must do to get the court to recognize your agreement for enforcement or for invocation. Again, very simple. You must show an agreement that's been signed by the parties and show at least some evidence that can convince the court of that jurisdiction that your agreement actually resulted from mediation. And they don't make it exhaustive as to what you must provide, but they give you examples. So for example, look at B1, the mediator signature on the agreement, a document being signed by the mediator that indicated that there was a mediation, an attestation by the mediation institution. So at SIMC, for example, when parties mediate and they settle, it is then open to the party seeking enforcement to come to SIMC for a document to certify that these parties came before us for mediation, and they did. And that can be used as evidence to help them enforce the contract under the convention. And for the last point, Jimmy can go back. The last point, even if you don't have any of the above, you can still use other evidence. So as I said earlier, it's not exhaustive. So it's really designed to be a very easy process where you just provide some evidence, and it's up to the court to then agree with you on enforcing your agreement or not. Next slide. Yeah, so this is a minor point. So you can even you can even enforce if an agreement is based on e-communications, for example. And in this time and age, that's not uncommon. And the convention also provides for translations. Next slide. Yeah. So I spoke about one party mediating, having an agreement, and bringing it to a country to try to record to try to enforce the agreement to maybe get the assets that are in that country, right? If it's not being paid. But what happens to the other party? Of course, before the court will allow the enforcement, the court will, of course, look at the other side and ask the other side, so what do you say? Should I really just enforce it? So, of course, it's open to the other side to ask the court to not enforce the agreement. And the grounds are fairly typical. They are quite standard contractual grounds. So, for example, a party to the agreement was incapacitated, right? Maybe he's not of legal age, for example. Or I always joke, maybe the person was drunk, and you can prove that. And the other point pertains to the agreement. It's null and void, right? Maybe it's not binding. Maybe the terms are too uncertain, for example. Or the agreement was modified, which means that there was some other agreement that took its place, and the agreement that's being used for enforcement doesn't really exist anymore. Yeah, but it's a matter of evidence, and it's up to the other side to prove all these factors. If we prove these factors, the court can then refuse to enforce the agreement. Next slide, please. Yeah, so there are more grounds here. So the obligations, the terms have been done. So for example, if money has already changed hands, if I owe the person 1 million under the agreement, and I paid that 1 million, and the other person is trying to enforce it in Singapore, I'll tell the court, no way, I've already paid the money. So you can resist enforcement on that ground, right? The terms are not clear, and the terms don't allow you to enforce. So I'll go into that later. And the other point is that I go into factors for refusal to do with the state of mind of the party, incapacity, the status of the agreement. Maybe it's been cancelled, it's been varied, or been performed. But another important thing is that if there are grounds for you to prove that the mediator was not independent, for example, after you have mediated, you find out that he had broken the rules, his code of ethics, he was not impartial. You can also raise that to the court as a ground of objection to object against enforcement. And before I move on, I'll take you to the 2 points at the bottom: public policy and not capable of settlement under the law. So these are 2 points that you don't need the party to raise before the court will refuse enforcement. So let's take, for example, a gambling contract. If parties agree to resolve their dispute via an agreement, and it's to do with, say, something that's morally reprehensible. Maybe this country has a particular view of gambling, and they do not want to enforce the agreement. They can do so, right? On the ground that is contrary to the country's public policy. So these are the grounds for not granting relief. So very simple, quite straightforward. Next slide. Yeah, so I'll go through the next slides very quickly. This is just if there are claims on the same dispute elsewhere in the world, the court that's enforcing can stay the application or the security. Next slide. Yeah, and other laws or treaties. So you're not deprived of any right you have to access other treaties. Next slide. Yeah, reservations. Maybe I'll just spend a little bit of time on this because this is quite important. So under the convention, I think 53 countries have signed the convention, but at the same time, when they sign the convention, the country can also put in at least 1 or 2 reservations. So one reservation is that you can carve out the government or government bodies, right? Which means that the convention then will not apply to agreements where the government or some government body is a party. That's 1. And 2, you can also make another reservation such that the convention will only apply in your country if the parties to that agreement have agreed for the convention to apply. Okay, so for example, when Singapore signed the convention, we didn't make the reservation. And so for example, for example, some countries may feel like they don't want the government to be enforced against, and then they may make the reservation. So it's really for comfort. Next slide, please. Yeah, effect, okay. Next one. Yeah, next one. Next one. This is on the signing ratification. Yeah, next one. Next one. Yep, so entry into force 6 months after the third instrument deposited. And as we explained earlier, it entered into force on 12 September. And now it can be enforced in some countries. And as time goes on, we hope that more and more countries will sign the convention and more countries will ratify the convention. And when that happens, we do see the Singapore Convention on Mediation becoming globally enforceable for settlement agreements in the same way that the New York Convention is for arbitral awards. Next slide, please. Yeah, so ratification. Next. Yeah. So that was our Singapore Second Minister for Law, who went to New York to deposit Singapore's instrument of ratification. And the other countries that ratified are Saudi Arabia, Qatar, Fiji, and I think Belarus. Next slide, please. Yeah. Okay, so when a country signs on to the convention, in some countries, they also need to implement the obligations into domestic law so that the courts know what to do and the lawyers in that country know what to do. So in Singapore, what we have done is that we converted the convention into local law under the Singapore Convention on Mediation Act 2020. So it provides a way for parties to know just how the courts will enforce the agreements they are brought to Singapore for enforcement. Next slide. And very briefly, right, I mentioned about how the bone and marrow of the convention is that it allows a party to bring the agreement to a jurisdiction. Maybe the assets are there that it wants, and you can bring the agreement to the courts there and ask the court to enforce the agreement under the convention, right? So in Singapore, under the Act, what the court would then do is that it will look at whether the criteria are met. Was it an agreement that came from mediation? Is there evidence of that? Was it signed by the parties? And if there are no arguments raised by the other side as to the grounds for refusal, the court would then proceed to convert the agreement into a court order. And with that court order, the enforcing party can then use that to easily enforce against the assets of the other party in Singapore if they do not comply with the payment terms under their settlement agreement, right? And I also mentioned that the convention also allows you to invoke the agreement as a shield if you are being sued. So if I'm in Singapore and I mediated with, say, a party in country B, for example, and country B now is suing me in Singapore, even though we have already resolved our dispute through mediation, I can then invoke the agreement as a shield to stop him from proceeding further in the court proceedings. So sword and shield. And the Singapore law was designed also to replicate the convention, but also make it user-friendly, so you know exactly what to do when you come into the country to try and enforce your agreement. Next slide, please. Yes, so I think that I've taken too much time, and the remainder of the presentation, I'll just hand over to Jomin, just to explain a little bit about SIMC. Thank you.
Yeah, thanks, Julian, for talking about the key provisions of the convention. I'm just going to spend maybe the next 5 to 7 minutes talking a little bit about SIMC, the Singapore International Mediation Center, as well as what we do over here. So SIMC, we are pretty small in terms of size and also pretty young. We were launched in November 2014. So we just celebrated our 6th anniversary last month. And the photo that you see over here at the launch day, you have Singapore's Chief Justice, Mr. Sundaresh Menon, and the Minister for Law, Mr. K. Shanmugam, Senior Counsel. And on the extreme left is our first chairman, Mr. Edwin Glasgow QC, and our current chairman, Mr. George Lim, Senior Counsel on the extreme right of the photo. So SIMC, even though we call ourselves, a international mediation center, but really our bread and butter is really to help people resolve their cross-border disputes effectively, timely, and efficiently. So some of the services that we provide, for instance, like what Julian mentioned, that in this time of COVID-19, businesses are being affected, communities are being affected. So in response to the business needs of the region, we came up with a COVID-19 protocol, and shortly after that, a joint one with JIMC, which is the Japan International Mediation Center. Julian also mentioned a little bit about hybrid processes and how mediation can be used with other dispute resolution mechanisms such as arbitration. So we do have an arrangement with arbitration centers around the world as well, and as well as with one of our sister organizations, the Singapore International Arbitration Center. So just to go into a little bit more about the SIMC COVID-19 protocol, and this, we are pulling this out because of the relevance of how the pandemic has really hit everyone, every business community in every corner of the world, essentially. So the protocol essentially provides for an expedited, economical, and effective process to resolve international commercial disputes during the pandemic. We commit to organize a mediation in 10 days, and the mediation can be done online, given the current travel restrictions. So it really makes it a lot easier for parties who are based in different countries, different parts of the world, to resolve their disputes through mediation online. Economical being, we, as a not-for-profit, we commit to providing special rates from SIMC, and also negotiated rates with the mediators who are being assigned to the case. And on this point, this is effective matching disputes with experienced mediators, and throughout the mediation itself, we commit to providing online support, even if your mediation goes into 5 a.m., 6 a.m. the next day. And it has happened in the last few months, because most of our cases, most of the disputes that come to us are high value, multi-party. They span across different time zones, and they are also fairly complex. And so we have been able to resolve some of these disputes effectively when parties file a case using the COVID-19 protocol. We mentioned our sister company, the Singapore International Arbitration Center, and this is really an up arrangement that we have with SIAC. And this is important because as we are talking about the convention right now, about how it's a game changer and how it allows for the enforceability of mediated settlement agreements, still, it will take time for more countries to sign up for the convention and for them to ratify it as well. So meanwhile, what do? We have this up protocol arrangement that actually marries the best of both worlds. It gives you the finality and enforceability of arbitration. It gives you the speed and confidentiality and without prejudice nature of mediation. So if a case goes to SIAC for arbitration, and halfway through the hearings, parties prefer to go for mediation. They come to SIMC, we arrange the mediation, and if during the mediation, a settlement is reached, the settlement agreement that parties sign can be converted into an arbitral award and be recognized in 160 countries under the New York Convention. This is our standard SIMC mediation clause that we encourage businesses and lawyers to include in their contracts. And I think more importantly is also our international mediator panel. So when we first started in 2014, I think we took pains to actually cull the best mediators from around the world to form our international panel. So they must have had a track record of high settlement. They're from all around the world. They know the law of the land. They know the language of the land. They understand cultures. They understand cultural nuances, and they are excellent with processes, and they're excellent listeners. They're excellent facilitators, and they join our international mediator panel, and they are from basically all around the world. We at SIMC, we do a lot of promotion. I mean, we promote mediation, not just in Singapore, but also in the region. And we have a lot of work in China, and also with our partners, CCPIT Mediation Center and CTEC. We have arrangements with them and partnerships, to cross-share knowledge, to cross-share training, for instance. And we also commit to training the lawyers and the in-house counsel, as well as the business community in that country, to understand mediation and how it works. So this is our work in South Korea, our partner KCAB. So pre-COVID days, we would fly around the region just to meet our partners, to encourage people to really take up mediation, and also, of course, to train and build capacity within that country. This is Japan, and this is India. And I'm coming almost to the end of the presentation, and to date we have managed about slightly more than 130 cases with a total dispute value of $3 billion US, with a settlement rate of between 70 and 80%. And this includes the up stats as well. The settlement rate for the AMA cases to date is very high also. And these are some of our overseas users. And what we found was that even if a case has nothing to do with Singapore or nothing to do with SIMC, we are quite heartened that parties actually chose to come to Singapore, to SIMC, to facilitate or to case manage the disputes, even though the matter has nothing to do in this part of the world. So in conclusion, we do see mediation as well as the Singapore Convention as the next game changer for international dispute resolution, the international dispute resolution scene. And with that, it means we are also seeing an increase in demand for solutions that are effective, that are binding, and by extension, what this would mean for businesses, what this would mean for in-house counsels as well as lawyers is that there will be a need for lawyers who can facilitate conversations at the negotiation table and who can work effectively with the mediator to resolve a dispute and to come up with solutions that are commercially sensible. Yeah, thank you. Thank you.
Thank you very much, and we are greatly delighted. I think the presentation that you have extended to us, Madam Lee and Jolene, has not only helped us to be able to understand the Singapore Convention on mediation, but at the same time, you have also given us a context of how the Singapore International Mediation Center works. I really like the fact that you also presented to us the statistics that help us to be able to appreciate the development of mediation. And I think it makes a lot of business sense when we are able to speak, especially in the commercial context, and we are able to talk about, yes, what's the cost savings and also what's the time saving, and be able to have value to it. So I think the survey you presented to us with regard to from the SIDRA, with regard to representing their interests, whether for mediation, litigation, arbitration, based on several factors of enforceability, impartiality, and speed and costs and finality. I think that also has given us some very great enlightenment. So I really, really thank you. And I also thank our host, Amanda, who has also posted in chat a request for the additional time so that we can be able to cover the next part of the discussion. So once again, thank you very much, Mr. Jolene and Madam Lee. And we are still coming back to you. We are now getting into the panel discussion, and our panelists will be able to give us their insights based on this discussion and also based on their experiences. So our panelists are based in Africa. They could be working in out of Africa, but we are looking at mainly them enabling us to be able to understand what are the implications to the national and regional trade and policy frameworks. And I think that would be a very interesting area for mediators to be able to understand, because then it could also impact the way that we do the work we do in this region, and also how we can probably be able to collaborate. So our first panelist is Mr. Juan Adenuga, who's the chairman at the advisory board, the ODR Africa Network Nigeria. He holds a BSc in estate management, and he established the Adenuga and Company, which is a firm of estate surveyors and valuers. He's also a fellow. He's a fellow of the Chartered Institute of Arbitration in the UK, and he's also a certified mediator. So we invite our panelists to kindly give us their comments in 5 minutes. Our next panelist will be Madam Jacqueline Oyuyogedenji, who is a non-executive director at the Nairobi Center for International Arbitration. She's also the managing partner of OMSIZI LLP. He's a fellow of the Chartered Institute of Arbitrators, and she is a certified and court-accredited mediator. She holds an MBA in global technology. Our host today, who is young mediator Amanda Maseno, will be able to give her remarks and views also. Then we will be followed by William Magan, who is a lecturer at the Catholic University of Eastern Africa in the Faculty of Law. He's a certified mediator and advocate, and also a part of the Agan and Associates. So kindly, our panelists will give you 5 minutes for your remarks. Yes, then our speakers will be able to get some key points. We will come back to our speakers to help us to wrap and close the sessions. So kindly, Chairman Juan, you may kindly start us off.
Well, great. Thank you, Wangari. Thank you, Jolene, and thank you, Zumin. I was hoping I won't be the first. It's always very nice if you hear from everybody, and then you sort of summarize. Yeah, I can connect to this by just going by the way I got into alternative dispute resolution. As I said, I worked in the real estate sector that was capital intensive. Any business you do in real estate development is capital intensive. And litigation was just not an option because of the amount involved in developing real estate, for instance. You find out that most investors will have to borrow money. And if you borrow money, there will be interest running. Now, if you go for litigation, there's always this tendency to seek for an injunction and stop everything while you go and deal with the litigation, which has nothing to do with interest you're incurring every month. So I've always wondered, is there another way? But the first thing that occurred to me was arbitration. And I wasn't considering mediation that much, because the key thing which you mentioned, which makes all the difference, is enforcement. So we wanted something where there can be enforcement and very quickly. But where you have so many brilliant lawyers around, arbitration again began to go the way, almost well, the way of litigation. And I was particularly concerned because if you're looking at the construction industry, you may be thinking of the big construction firms, but no, there's so many smaller subcontracts involved that you work with. What happens to those ones? And those ones are the people that sort of focused me on the small and medium scale enterprises. Being an African, I'm so concerned about the growth, the economic growth in Africa. And I tend to just look away from the big companies. I'm not interested in those. I'm interested in the growth of all the smaller businesses. They can't afford arbitration. They can't afford litigation. And that's how come I found myself working, I think I was lamenting, and I came across the founder and she was laughing and telling me, the founder of ODR Africa, which is Morenike, look, the solution is mediation. Not only mediation, online mediation. And that's how, again, we sort of started exploring how we can assist people in that sector. Now, we started working on mediation, but then we were not yet aware when we started of Singapore Convention. So we came up with some ideas to assist that sector, small and medium scale enterprises, get easy access to justice in an effective process that is quick, as you said, cheap, I mean, very effective as far as cost and time. But we were worried about enforcement. So what we're thinking about is there a way of converting a mediation settlement into an arbitration award so that it can be easily enforced? But here comes Singapore Convention, and we were all watching out for it. So we were happy. I remember reading the articles even before the 19th of August. I remember reading it months before. I'm praying for the 19th of August, 9th of August, is it? 2019. And I remember asking what has happened, what has happened, what has happened. But I got to understand the process that you have explained better now, because 3 countries had to help put the thing into force, which has now happened. And actually, at that time in Nigeria, we were already rewriting our Arbitration Act, because there had been modifications that have come up, and there was a bill before our National Assembly to adjust one or two things that were not serving Nigeria very well there. Then we realized what was happening with the Singapore Convention and thought, wait a minute, we might as well incorporate this. So it comes up as a local law so that we can properly present to New York and maybe be one of those that would have had this thing ratified. And already all of us are acting on those bases, because we are now in the pandemic. We are having to go into all sorts of policies. Certainly, obligations that had been arranged before can only partially be met. Nobody was prepared for this. Suddenly, there was a lockdown. If people had placed orders, what can they do about it? Also, there are border closures. What do we do with border closures? Well, the only thing we can do now is to just get ready, because definitely there is going to be some disputes arising from all this. People will be disappointed, and how do we resolve it? And it's always better through mediation. In my opinion, when you go the way of mediation, you focus on the parties, and then the parties to focus on what is important, what they want out of this dispute. I believe when you go the way of litigation or arbitration, you are focused on the adjudicator. What is the adjudicator going to come out with? And you can't really plan, until you've heard from the adjudicator. So it's really wonderful that we now have an international or a treaty, treaty that comes with enforceability, because that is the primary concern of people in business. I just want to put this past me and move on. So I think for now, I can't time myself. I think for now, I should just allow somebody else to talk. I don't think this is the last time I'll be talking. So, well, this is great. And most of all, I'm glad to share with people from Kenya. I've been meeting people from Kenya, and there must be something about Kenya, because all the people I've met have been so smart and bright and quick. So I'm glad to meet people from other parts of the world, because it's a global village now, and we just must learn to work together to push forward. So let me pause now and let somebody else talk.
Okay. Thank you very much. Chairman Wan. And that's the chairman of the advisory board of the ODR Africa Network, and based in Nigeria. And we actually have the founder, who's Madame Morenike. She's also on the call today, and she will be speaking to the African International Mediation the week seminars. Actually today evening at 8 p.m. she will be speaking to us. So we actually have a very good team from Nigeria, and that's why you're connecting with Kenya, and especially connecting with the next bright and sharp one from Kenya, just as you've said. So we invite Madam Jackie Oyiyo-Gedenji, who is a non-executive director at the Nairobi Center for International Arbitration in Kenya, to kindly give us her 5-minute remarks. Welcome, Jackie.
Thank you, Wangari. Thank you, Adejuwon. The reason that we try to stay sharp and bright is so we can keep up with Nigeria. Thank you also to the team from SIMC for your very detailed presentation. So just a few reactions from me in the 5 or so minutes that I have. Firstly, I think the convention is quite timely, as everybody has said, in terms of just giving mediation a foothold and raising the profile of mediation as a dispute resolution mechanism, specifically in international trade and investment. Locally in Kenya, we have had a little bit of prominence beginning to attach to mediation, in the sense that it is recognized in our constitution as one of the forms of alternative dispute resolution. And through that, the courts now have a court annex mediation program, through which cases that are filed in court can be referenced to mediation. The court maintains a list of court accredited mediators, and to that extent then ensures some level of standards, and ensures that those disputes that have been referred to mediation through the courts are settled within a minimum of 60 days. Having said that, the practice varies in different jurisdictions across the African continent, as you can imagine. Perhaps jurisdictions such as Kenya and Nigeria, and indeed South Africa, are at the forefront, and Cairo, I believe, are at the forefront of establishing mediation as a dispute resolution mechanism. But suffice it to say that a lot of African societies and cultures did recognize some form of mediation in their dispute resolution mechanisms. It may not necessarily have been in the formal style that we are now accustomed to globally, but certainly there was a recognition that a third party neutral could come in and sit down with disputing parties and facilitate the negotiation of their disputes. So to that extent, we don't have very far to go in terms of convincing our populations that mediation is a way to go. But in terms of the commercial and sort of trade and investment space, we do have some way to go, and I'll explain why. As I think Adejuwon said, there is a perception of mediation as the lesser cousin of arbitration. It's the little brother that you tolerate, that you take everywhere with you because your mother has said that you have to take mediation along. But we're beginning to see a change, as I've mentioned, certainly in the Kenyan court system. Mediation is appreciated and is recognized. However, for us to give to this convention, we then have to ask ourselves in Kenya and perhaps across the globe, what kind of frameworks in terms of the legal and institutional frameworks we're going to establish to give some force to the convention. My first challenge as a very casual reader of this convention is the whole, is it Article 8 that allows you to exempt yourself from the convention? So even if the country is a signatory, it can still decide that it is not going to accede to the convention in terms of a specific agreement, a specific bilateral agreement or a multilateral agreement. However, the opportunity still lies, I think, in Article 12 for regional blocs to sign, to ratify, to accede to the convention. So we do have to ask ourselves, I think each and every jurisdiction within Africa has to ask itself whether the time has come for it to embrace mediation. And if so, then how it's going to do that through its legal and institutional frameworks. Here in Kenya, I think it has been mentioned at least 3 times that I am a non-executive director of NCIA. And just to say that NCIA, despite the name, is a little misleading in its name. Not only do we facilitate arbitration, we also facilitate mediation. So we do maintain a panel of both arbitrators and mediators for both domestic and international disputes. And to that extent, then, we will be looking to broaden the mediation panel. And I think there is a challenge for mediators, for parties, for party representatives, just looking at the basis on which a court that has, or a jurisdiction that has been asked to enforce the convention can deny the enforcement. There is some additional skill, I think, that will be required of mediators and parties. Specifically, incapacity is fairly obvious, as was mentioned by Julien. But when you talk about null, void, inoperative, incapable of performance under that particular law, then I suppose in the course of the mediation, those are questions that have to be in the back of your mind in terms of enforcement. Yes, mediation is a consensual process, and it is a process that parties sort of bind themselves to the outcome. But where they don't, then one party obviously has to seek the enforcement, and that's the whole point of this conversation. So as a mediator, as parties, again, an additional onus in terms of clarity of obligations arising from the mediation settlement agreement, clarity in terms of what is expected of the parties once the settlement agreement is signed. I see a possible challenge, and this is, we can discuss this in the whole confidentiality of mediation settlement agreements and the whole process of mediation, because confidentiality is assured at 2 levels, both the fact of the mediation and the output of the mediation. So when we talk about the party seeking to enforce the mediation settlement agreement, having to provide evidence that the settlement agreement resulted from mediation, what exactly are we saying? Is it not sufficient to say that we have a mediation settlement agreement? Is that sufficient? In Kenya, for example, will that be a sufficient threshold for us, or will we be looking to a higher threshold? And certainly when you are at the point of enforcement, forced enforcement, should I say, then it means, or coerced enforcement, then it means that somebody is starting to renege on the mediation settlement agreement. And is that party then going to say, this is not how I meant it in this other way? And this is why I say that there is an additional onus both on mediators and on parties to be very clear in terms of the outputs of their mediation settlement agreement. In terms of the parties, the countries that have already signed, what we're seeing in arbitration certainly is that Africa is largely, and I say this very delicately, ignored in terms of being a forum for dispute resolution, and secondly, having its professionals recognized as competent and capable in dispute resolution. So how do we disabuse the world of this notion that we do not have the capacity? We have to, like I said earlier, we have to build our institutional frameworks. We have to expose our professionals to disputes that are in the international domain, and we have to make sure that even as we expose them, then the competence is being built, the confidence is being built, because largely in investment and trade negotiations, Africa is the place of performance, and therefore Africa should have a central place in terms of the determination of these disputes, so that we don't see some of the challenges we have seen. And I know my brother from Nigeria can attest to this as well. Some of the awards, the arbitration awards that are being determined against states. And this is why, for example, an African state may be reluctant to sign up to the convention to the extent that it feels that there is some level of bias. Now, this is less likely in mediation because, like I said, it's largely the party's determination in terms of a settlement agreement. But where one party then starts to renege, then we start to challenge ourselves in terms of how do we make sure that our multilateral, our bilateral agreements include mediation clauses, include the convention, and include the opportunity for these disputes also to be heard on the continent of Africa. I want to stop there, having incited some debate and some conversation, and allow the next speaker to take it forward. Thank you.
Yeah, thank you very much, Madam Jacqueline Oyiyo-Githinji, and for your remarks. And that's why we say that we will invite our colleagues from the Singapore International Mediation Center to also add in their insights after we have got views from the panelists. Not necessarily that they are going to be responding, but it's also today is an opportunity for us to exchange, and we could always be able to further this discussion as we go on. So allow me to kindly make an interchange. We will invite our Mwalimu lecturer, William Magan, from the Catholic University of Eastern Africa, the Faculty of Law, a certified mediator. And he's also part of the Agan & Associates, and to kindly give us his remarks. And then after that, we will then be able to have Amanda or give us remarks, as she's also giving us the comments that were in the chat. Then we can come to Jolene and Madam Lee. Kindly, William Magan, yes, kindly 5 minutes. Thank you.
Thank you very much. Zuomin Lee, Jolene Te, a wonderful presentation. Thanks to my brother, our elder brothers from Nigeria, Adenuga. I have sensed the passion that you have in developing business in Africa. Thank you, my colleague, Jackie, for reminding us of the place of mediation as it was, I would say, the lesser cousin. But I'm sure today we will all agree, indeed, that this is now the new kid on the block, and is no longer going to be the lesser cousin, or the third cog on the wheel. Allow me to, first of all, also give my disappointment, share my disappointment in my own country. I'm not very happy that Kenya is not on board. But I'm sure Jackie could be having some insight, information about the possibility of what is going on in our kitchen. Reason being that Kenya, in this part of the world, is indeed a business hub. So I have faith that I'm sure that someone is watching, and that we do not want to be left out. Left out of this very wonderful phenomena that is taking place around the world. Myself, I wear two hats, and I will really perhaps call upon the faculties of law in various universities to stop the bureaucracy that we usually have. I know I will be touching a bit on it later on, because we have a bureaucracy when it comes to curriculum development and curriculum revision. And so far, because I teach alternative dispute resolution, I am now officially seeing my notes as yellow notes because I will need to very quickly go back to my notes and do a very quick revision in light of the Singapore Convention. I would also want to call upon various institutions that are engaged in mediation training, and so are associations, because they too have to very quickly throw their yellow notes, trash their yellow notes, and very quickly unlearn and relearn because of what is going on as shared by our international speakers from Singapore. Now, perhaps also call upon practitioners to read the signs of times, because we've seen this, and I'm very excited to see that UNCITRAL was very much and is very much part of the Singapore Convention. And those of us that know the history of arbitration, why I'm saying that we read the signs of time is because the moment UNCITRAL stepped in, within no time, we had a UNCITRAL model law. And within no time, countries were being called to go back and amend their arbitration legislations so that they can conform to what was going on. We know the enforcement that the New York Convention brought on board, in terms of enforcement of foreign awards. Now, we are actually looking at the Singapore Convention, which is a convention on international mediation. And it is very clear that the subject matter is international. That then would mean that those of us, especially in Africa and especially Kenya, who will be left out of this will not benefit from the advantages that our international speakers have actually shared with us about this particular convention, or this particular convention. So for me, I'm very excited, and perhaps let me just share, because I was called upon to also share some experience, not directly related to mediation, but related to a disappointment because Kenya is not a signatory to a very important protocol within our region here. In this region, we have Africa Regional Intellectual Property Organization. And there is a very important protocol, and that is called, that protocol is the Banjul Protocol on trademarks. Now, Kenya is not a member, and I can assure you, we are feeling it. We are feeling it. The rest of the countries are. So I hope that Kenya will perhaps learn from the disadvantages that we as practitioners are having by not being members of this protocol, so that we can quickly jump on the bandwagon of the Singapore Convention. Those are my few regards, and thank you so much.
Yes, thank you very much, Mwalimu William again for your remarks. And at this juncture, kindly I will invite Amanda Maseno. Amanda will give us her remarks and also highlight the key comments that have also come through the chat that we have. Thank you very much. Amanda, kindly.
Okay, thank you very much, Wangari. So I think all the speakers have been able to capture basically all of my thoughts. So I think I will just summarize some of the key things that I digested from the presentation, and especially from the perspective of a young mediator, someone who has just joined the space and is eager to learn and eager to just engage with other people. So one of the things that I noticed from the speakers of today is that one of the major things that the Singapore Convention sort of relies on is rules of local states, and the fact that local states have to be very engaged in order to ensure that these the Singapore Convention comes into effect, and they make the space easier for mediation to actually take place and for people to be able to engage. So building upon what the speakers have said, I would also like to highlight what Ms. Jackie also shared with us, and that is the role of, in terms of legal institutions, in terms of legal and institutional bodies, and the role that they can use in order to ensure these rules actually come into effect. So, for example, here in Kenya, we just had a proposed mediation bill of 2020, which has which I think is a right step in order to acknowledging mediation and making the space really easy for mediators to be able to engage, to be able to have enforcement policies, all these things. So I think from my perspective is that this is really helping in terms of growing the mediation space, recognition of mediation, and hopefully having more people delve into that area. Also, in terms of institutions, we have very many institutions. We have both the Quota Next mediation program, which Jackie also mentioned, and I think also we have those institutions that are really helping the mediation space grow, which I think is also a very good step, and it's heading in the right direction. So the second thing I think is the fact that the Singapore Convention, if ratified in Kenya, or rather when ratified in Kenya, because I believe it's just a matter of time, is the fact that it encourages the international, it opens up Kenyans to international practicing, cross-border mediation, enforceability, all that. So I think that's also something that is helping us grow and move in the right direction. And the third thing, possibly, if I can just state from my perspective as a young mediator, is even these training institutions, what exactly is their role in ensuring that not only are they just training, but there's also the aspect of engaging with bodies and engaging with any forms of championing for better for people to be able to know about mediation and also to enforce some of these policies, these international policies. So I feel like even the training institutions have a huge role to play in that respect. They can make recommendations because they themselves have people who are practicing in the arena and also have the role of mentoring and introducing young mediators. So I think that the training institutions also have a very big role to play. So having said that, I think those are my comments, and I've also highlighted what most speakers have been able to share from their respective jurisdictions, and we just hope to see that the Singapore comes into effect in Kenya, the Singapore Convention is ratified in Kenya, and from there we can be able to build up as a global entity. So I'd like to now proceed to the comments and just highlight a few comments of what people have been sharing during this session. So I will start with Washika Washira. She says, great presentation from Jolene and Zumin Lee. So yes, we also appreciate our speakers for today. She also adds that international mediation is having a growing demand. As mediators, we stay put and familiarize ourselves with existing conventions like the Singapore Convention, which I also agree with. We also have Pauline Wahinya, who also says, thank you very much, Wasilianahub, and for the opportunity. And she also appreciates that it was a great presentation. Grace Nyongasa also says, very timely discussions, very insightful with quality presentations. And Wangari Kabiru also states that this means co-mediation, the Singapore Convention. In light of the Singapore Convention, we now have co-mediation with a mediator from different parts of the world. Yes, so I think those are the main comments that I will highlight. At this juncture, I would like to turn it over to Wangari to give us the final views. Thank you.
Okay, yes, thank you very much, young mediator Amanda Maseno, and also we appreciate the views and remarks that we have been able to receive from our panelists today. Our panelist today was Mr. Juan Adenuga, who's the chairman of the ODR Africa Network based in Nigeria, and Madam Jackie Oyuyo-Githinji, an executive director at the NAIROBI Center for International Arbitration, Kenya. We also had lecturer William Agan from the Catholic University of Eastern Africa Faculty of Law, and also the remarks from young mediator Amanda. So kindly, ladies and gentlemen, you'll allow me to invite Mr. Jolin to kindly give us his closing remarks in the next 5 minutes. I believe it is not a closed discussion, and this is a discussion that can continue on in further times. And yes, but for today, we will need to be able to close in the next 5 minutes. So welcome, Mr. Jolin.
Thanks, Wangari, and thanks everybody again for the chance for SIMC to just speak today. And I think that quite often I learn more than I share. And I think that in the past 20 minutes, I've learned a lot more about mediation in Kenya and Nigeria than I did. So I'm very thankful for that. And my only regret is that we can't be meeting face to face and have more of a chance to talk about mediation, dispute resolution, arbitration, and about our countries. But thanks very much. I guess with the time that I have, I will just join the bandwagon and encourage countries that have not signed the convention to sign the convention, and for those that sign the convention to ratify or approve the convention, because the chain is only as strong as the weakest link, and the more countries sign on, the more we can access the benefits of the mediation and promote trade and investment around the world. So I think that point is important. And my general points are, I agree that too often mediation was seen as a lesser cousin, right? So coming out into the legal industry, people have often asked me, why are you doing in mediation? Why are you not in litigation, right? Why are you not filing lawsuits and doing pleadings? Why are you talking about mediation case statements? But I think the tide is changing. And in the 1 year or so since I've been at SIMC, and we speak to various people, we find that the tide is changing because the users want it. More so than the lawyers, for example. We have found that the business people want to use mediation because they see mediation as a very effective way, a very practical way to resolve their disputes. So I don't think the tide will change. So on the issue of the legal frameworks, I think the issue is not whether or not these frameworks are insurmountable. The issue is how do we overcome them in the quickest possible time. And having gone through the same experience in Singapore, I'm confident that every country will find its own way to implement the convention and overcome any difficulties in doing so. And maybe I'll just pick up on a few points. So I think that Ms. Jackie made a very good point on the role of the mediator, especially because the convention talks about the standards of the mediator, their impartiality, their independence. So on that point, we do see that the convention has also resulted in a renewed interest at the quality of mediators, the training that you can get as a mediator, and that will be important. But one other point that I'll add to that is that way beyond the mediator, another important role is the mediation advocate. And who I'm talking about are the lawyers in the mediation. Because for commercial cases, quite often the companies are represented by lawyers. And these lawyers are the ones that really have to understand mediation as they bring their client to mediation with the mediator to come to a discussion and resolve the dispute. And speaking about the terms of the agreement, to make sure that the terms they are crafted make sense from the client, and these are practical terms that can be enforced, that can be carried out, you see. So the role of the lawyer is actually very important in mediation. And now we are seeing more spotlight on that, and more lawyers are going to get trained for mediation. Even though they are not going to be a mediator, they know that the skills will come in useful when they are an advocate in mediation. And that's important because the solution to terms that are not clear, not comprehensible, is really having a good lawyer there to protect your interest as a client. And but the other point is that if the terms are not done properly, the court will also not enforce the agreement. So that's the other point that I was coming to. Then there's another point that was made on confidentiality. And to me, from what I've seen, the mediation is confidential in the sense that what happens in the case, the details are actually private and confidential, just as arbitration is. So in arbitration, we've been able to enforce the awards around the globe, but it's possible to just get a redaction if you need to. One can always apply to the court to redact certain information, and bearing in mind that enforcement is a matter between the two parties only. So I don't see that as too big an issue, confidentiality-wise. And quite often we find that parties are also okay to agree that they can announce that they have gone for mediation, even though they say that we'll keep the terms private and confidential. So I don't think it's a big problem, and it's not insurmountable. And I think my last point is that on reservations, maybe I didn't spend a long enough time to talk about it, but I think one reservation is that the government of a country that signed the convention can itself opt out of the convention. And that means that in an agreement that involves the government as a party, the government can say that such agreements cannot be enforced under the convention. Well, that's actually not really particularly special because the government of a given state may have very good reasons why it doesn't want to do that. But I think the point that I forgot to make was that even if you don't have the reservation, right, there are many businesses, purely business to business contracts that do not deal with the government at all. They can still benefit from the convention. And even if the government does not make the reservation, Article 5.1d of the convention allows the parties to state that the convention will not apply. And they can do so by simply saying that the convention will not apply to the agreement. So they can opt out of the convention through the terms of their settlement. So I think the key thing is to bear in mind is that mediation is all about consent. It's about party autonomy. And the convention seeks to strike a balance between enforcement and the parties' rights to consent to enforcement. And I think that after about 3.5 years of discussions and answer trial, they have struck a good workable balance. And I'm confident that the convention will be implemented well wherever it's signed and wherever it's ratified. And actually, my last point is a little bit of anti-climax because I'm going to share on the experience at SIMC, which is that I think 99.999% of our cases, parties come to mediate, and after that, they don't see the further need for enforcement. And I think that that's because when parties actually settle, they're surprised that a dispute that just seems so out of control, so serious, can be mediated and settled. And people come to terms with it because you only agree to sign when you can live with the terms of the agreement. And when that happens, they will just comply. And we don't see a compliance problem. So we hardly see any case where a party even wants to consider enforcement of the agreement under, say, the Singapore Mediation Act, under AIMWEEK2020, for example. And that's really amazing. And then people may then ask, then what's the point of the convention? Well, the point why we are here. And to me, as I said earlier, the point of the convention is that the ability to enforce really gives people confidence in using mediation, as what Gion had said, you know. And that to me is the point that I'll leave you with. And I'll just pass the mic to Juomin in case she has something to supplement. Juomin, please.
Thanks, Julin. Thanks, panelists, Juwon, Jackie, William, as well as Amanda. And I think like what Julin mentioned, we give a presentation, but at the end of the webinar, we learn so much more than we present. And I think this is a very humbling experience because in the course of our work, being in Singapore, being in Asia, we don't get many opportunities to go as far as Africa. And in a on a normal day, we would be sitting in a seminar, seeing you guys face to face, shaking hands and hugging, and maybe clinking glasses and having coffee together. But I share Julian's views in that this has been very enriching for me, at least, and I hope that our presentation has made a difference to the audience here as well. I just have maybe 1 or 2 points which I want to share, and this really builds on Julian's point about how the lawyer or the counsel, or working as a mediation advocate makes all the difference in the mediation room, because you need to know how to work with the mediator to come up with a solution that is commercially sensible, that is final, and that is clear, and in which all parties understand and are clear about what is expected of them. And I think in the last few years, or perhaps in the last few decades, mediation is always seen as the weaker cousin, because people propose mediation when they are in a position of weakness. But over here, what we have seen, and which we can be convinced of the fact that people propose mediation because they are in a position of strength, because you want to come to the bargaining table, or you want to come to the negotiation table only when you have you feel you have a very strong position. And with all the insight and all the sharing that has gone on in the last 1 hour, we see that even something like mediation, there's just so much to learn. It's a whole academic discourse. It's a whole you could write an entire thesis that is thought-provoking, and I'm sure that this discussion, all these thoughts and insights will be ongoing, not just in Singapore and the region, but certainly in Africa, in Kenya. And we definitely want to open this, keep the conversation running, and keep avenues open for further discussion, even if it's sensitive, even if it's thought-provoking. Yeah. And lastly, I think really the value of mediation, at least what we see here at SIMC, is really when parties come into the mediation room, they hate each other so much that they can't even look at each other in the eye. So there's a lot of acrimony, there's a lot of negativity, there's a lot of unpleasantness that goes on. But at the end of the day, through mediation and through a very skilled facilitator, we see reconciliation, we see relationships being restored, we see restoration, we see repair, and we see how things are being bridged, and it's a brand new day altogether. And I think this is the value of mediation. This is what really matters at the end of the day: people, relationships, and this is something that is truly to be encouraged.
So once again, we take this opportunity to thank our speakers for today, with Mr. Tejo Lin, who is the Deputy Chief Executive Officer of the Singapore International Mediation Center, that's SIMC, and Madam Liz Omin, who is the Center Manager. And also we recognize our panelists for today, who have also infused in now the context from Africa, and also at the same time ask questions which are for all of us to be able to consider with regard to the Singapore Convention. That is Mr. Juan Adenuga, who's the Chairman Advisory Board of the ODR Africa Network, and Madam Jackie Oyuogedenji, and an Executive Director at the NAIROBI Center for International Arbitration, Kenya, our young mediator Amanda Maseno, and also our lecturer William Agan, Catholic University of Eastern Africa. So just in closing, what is the Singapore Convention on Mediation? So a uniform and efficient framework for international settlement agreements resulting from mediation. The Singapore Convention applies to international settlement agreements resulting from mediation concluded by parties to resolve a commercial dispute. It provides an efficient and harmonized framework for the enforcement of international settlement agreements resulting from mediation, and for allowing parties to invoke such agreements. today's discussion, we believe, is part of much more deeper discussion, and many more times we'll have the discussion with regard to the Singapore Convention in Africa, and we look forward to be with you again at another time. So today, this was our session, and this was our session at the African International Mediation Week and Strategy Conference on Tuesday, the 1st day of December 2020. And this is our morning session at 9 a.m. in Nairobi, Kenya, at this annual event for mediation and dispute resolution professionals in Africa. And we thank you for your time. I kindly hand over to our host today, Madam Young Mediator, Amanda Maseno. Amanda, kindly.
Okay, thank you very much, Wangari, for that. So before we close, I think I'd just like to read one last comment from Mr. Adenuga. And he says that I have a lot of admiration for those who put the Singapore Convention together. I find it has something more than the New York Convention, which is the non-requirement of reciprocal agreement by a state for a party in that state to rely on application of the Singapore Convention in another state that is subscribed to the use. Yes, that is subscribed. Yes, that is subscribed to the use. So I think that is the last comment that I will mention at this point. And I'd like to appreciate our speakers for the day and our panelists, as well as our facilitator, Wangari Kabiru, and everyone who has been able to join the session, the participants during the session. Thank you for your insights. Thank you for your time. Thank you for engaging through the chat portal. Thank you for coming for this session. And hopefully we look forward to future engagements together, and we can be able to learn and share in the future. So at this juncture, I'd just like to, we will close with the National Anthem of Kenya, and I will just recite the words in Kiswahili. E Mungu, nguvu yetu, ilete baraka kwetu, haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi. Okay, thank you very much.
Thank you, Big Head.